This is a provision that every contract that you draft must have. This is called severability. And what that means is, let's just say, for instance, if this contract gets adjudicated or goes to court, and they say, well, for whatever reason, this term of 12 weeks is unreasonable. They cannot then say, since this provision is not reasonable, or if it's unenforceable, we're going to null and void the whole contract. They can't do that if you have your severability clause, which states that if any one of these other provisions become unenforceable for whatever reason, you cannot strike the whole contract. Every contract you draft must have this provision. I mean, you can leave it out, of course, but if you, for whatever reason, find yourself in court and they strike one provision, then they can trash your whole contract. So I'm not going to say what you must and must not do, but if you want your contract to be as solid as possible, this is a provision that you will put in there. Also, this agreement shall not be modified except by agreement of bound parties. Termination of agreement may be done via written or via 10-day notice in writing sent via email or first class post office mail too. And then they have the respective addresses of both parties. And if you have 5 parties, then you would have the 5 addresses. Okay, and this just, as it explains, shows by what terms or by what methods that the contract can be canceled by either party. Each party signing this agreement, which is in its entirety represents and warrants that he is duly authorized to sign this agreement and bind the party on whose behalf he is signing, and that this agreement supersedes any and all prior agreements. Okay, another provision that says many things with very few sentences. First of all, it is attesting that each person signing this agreement is authorized to do so, or if someone is signing this agreement on behalf of another party, that they're authorized to do so. So for in this example, the trustee is signing that he is authorized to sign on behalf of Brazen Trust. Okay, that does not apply to Clive Davis. Clive Davis is simply saying he is authorized to sign this agreement for himself and that he's legally able to do so. Okay, and the second part is that this agreement supersedes any and all prior agreements. Okay, so what's being said here is a setup to avoid any type of issue from some sort of prior agreement that may have been voiced or stated prior to this contract being written up. Because of course I've come across problems where people revert back to what was discussed prior to an actual contract and thinking that is binding on the contract or it is a part of the contract. And so this provision is a standard operating procedure to prevent such confusion. All right. So they're saying that, listen, whatever we had beforehand, all of that is in the trash. This agreement that we're signing right here, that we're authorized to sign right here, right now, this is the entire contract, and it is the only contract that has bearing on our agreement. Okay, and then you have your signatures. Kaheen Smith signing for Brazen Trust, trustee, without recourse to trustee. And that, of course, means that the trust is the responsible party, not the trustee. Okay, when you're a trustee signing for a trust, you are not held responsible. And you make that clear to whatever party that contracts with the trust by this disclaimer here. Trustee signing without recourse to trustee. You can put Kaheen Smith by or for Bronze Trust, or you can put Bronze Trust by Kaheen Smith on the signature line. Again, a lot of these things are fluid. Once you're familiar with the particular law and how it operates, you'll be familiar with the terminologies that you can use and adjust. All right, Clive Davis going by his DBA. Now I want to come back to something really quickly. This is endemic in all contracts. Okay, the contracts that this phrase will not appear on are contracts that are inconspicuously, in my opinion, that's my opinion, trying to glue you to provisions, rules, and obligations that you cannot see. For example, the DMV handbook alludes to the California or the motor vehicle code of that state. So if you're looking at California, you're looking at the California Vehicle Code. If you're looking at Texas, it may be under a different heading, but it is still equivalent to the vehicle code. I forgot what Texas calls their manual that includes each and every rule that they have in order to operate a vehicle on their roads. But it is equivalent to the California Vehicle Code. Now, this provision helps inform you that there are no other hidden provisions like those in the DMV handbook to this contract. Okay, the DMV lets you know, and it states in the 100-page handbook that to get the full understanding or to get the full range of rules, regulations, and obligations, you are to refer to the California Vehicle Code book, which is 1,000 pages long. The Texas Vehicle Code book is 2,000 pages long. And in all of these manuals are additional rules and regulations that you are to be bound by. For example, that is where you will find that you're obligated to be basically drug tested on the side of the road via a breathalyzer or whatever method that state allows. You won't find that in the DMV handbook per se, but you will find that definitely in the operating vehicle code book or vehicle code manual. So they will not have that contract for DMV. They will not have that this is the agreement in its entirety because they're binding you to an additional manual. Okay, and you just have to read carefully. You have to know what you're doing. You have to know what contract law is and how they catch you, because incorporation by reference is inherent in almost all contracts. Okay, and it can be deadly if you don't see the clauses on these particular contracts. Okay, if you don't understand or understand that when you sign something that incorporates another manual or another set of rules by reference, you're also bound by those rules, even though you don't see them, even though they're not visible on the contract, the actual document you're signing. You're still binding yourself. Okay, we went over that in the one of our webinars for my members who are registered on the course or on the website. Okay, registration is free. Those members who registered for free, I took them through the actual DMV book and I showed them the actual binding terminology from the DMV book that made you obligated to understand all of the laws and rules in that 1,000 page motor vehicle code. All right. So now we're going to go to, now this is a simple contract, a simple form of this type of contract. Now we're going to go to the complex form of this contract agreement. Okay. We're not going to go over all of it, but I'm going to just brief you on the different provisions. I'm just going to introduce you to the provisions basically by stating what they are and how they expand this type of contract. Okay, but these are the basic provisions that you would do for, say, someone you trust moderately, or that if you're doing a contract with a friend and there's not a lot of money involved, this would be a contract that you would do for them. Okay, you would draw up or have drawn up, and or an acquaintance, whatever the case may be, and then you would proceed with this contract. However, for a lot more money and for strictly business and for people you don't know well enough to trust, quote unquote trust, I put that in quotes always, you would have the following type of contract. Now this is the same contract with expanded provisions and expanded details. Okay, there's a little more detail in this contract. Same service. This is basically the same contract because the same parties are involved and the same services involved, with Clive Davis providing a service for Brazen Trust. The same Blog Talk hosting. Okay, same terms, same payment. Okay, everything's the same except for there are more provisions and they're detailed a little more specifically. Terms, payment, due notice, confidentiality. Okay, that is a different aspect of this contract. It involves the confidentiality of the parties. It involves indemnification, remedy. Okay, this contract speaks to what happens in the event that the contract is breached, what constitutes a breach of contract, how to resolve it, right? Dispute resolution. Okay, we have our entire agreement and severability as we had in the previous contract, or in the smaller contract, the simple contract I call it. Okay, same provisions, amendment here, names. Okay, we have a difference here, governing law. We didn't have that in the first one. Notice. Waiver of contractual right. Attorney's fees to prevailing party. So again, in this contract, which separates it from the first contract, or makes it an expansion of the first contract, as we're talking here about what happens in the event that there's a breach of contract and how to resolve that breach, what methods will go about, and getting towards adjudicating the issue between the parties concerning breach of contract. Okay. So again, we talk about due notice. We talk about confidentiality. Okay, what information will and will not be revealed between the parties or to third parties. Indemnification. All right, releasing one party or the other from liability of claim. Remedy, which discusses what one party may do in the event that another party fails specific provisions of the contract or breaches the contract. Dispute resolution, the steps and methods by which we can seek resolution of any problems that might arise. Again, the same things that we had in the 8, 9, and 10 are the same elements that we had in the previous contract. So are the names, of course. Governing law. Now this names which state shall govern the rules of this contract. And again, we have these waiver of contractual right, which means that if a party fails to uphold one part of the provision of the contract, that does not mean they waive any other provision of the contract. It just may be an oversight on that party's behalf. Attorney's fees to prevailing parties. In the event that it gets adjudicated, the loser will basically pay the fees of the winning party. Construction and interpretation, which basically says that both parties agree to the exact way that this contract is written up, and the courts will not be allowed, or the courts will